Hi, hello everybody. This is Uma from Success Law Classes. Today we are going to discuss with regard to new criminal law bills in India. All about India's new criminal laws, that is Bharatiya Nyaya Sannihita 2023, Bharatiya Nagarik Suraksha Sannihita 2023, Bharatiya Sakshi Bill 2023. So these three new bills, that is Indian Penal Code 1860, was replaced with Bharatiya Nyaya Sanhita Bill 2023. It will have 356 sections instead of 5 level sections in IPC. 175 sections have been amended, 8 sections have been added, and 22 sections have been repealed. Coming to Code of Criminal Procedure CRPC 1973 to be replaced by Bharatiya Nagarik Suraksha Sannihita 2023, it will have 533 sections instead of 478 sections in CRPC. 160 sections have been changed, 9 sections have been added, and 9 sections have been repealed. Indian Evidence Act to be replaced by Bharatiya Sakshi Bill 2023. It will have 170 sections instead of 167 sections in Indian Evidence Act. 23 sections have been changed, 1 section has been added, and 5 sections have been repealed. Coming to the highlights of these new criminal law bills, Terrorist Act is defined as a separate offence under the Bharatiya Nyaya Sannihita. It will include acts which attack India's unity, integrity, sovereignty, security, economic security, or spreads terror among any group. Offence of sedition omitted. BNS penalizes acts endangering the unity and integrity of India, that is in clause 150. While sedition criminalized acts against the government, the BNS replaces the government with the country. Rajdroha has been changed as Deshdroha. Citizens have the right to speak against the government and it should be protected. But acts against the nation cannot be tolerated. Mob lynching has been made a separate offence under the Bharatiya Nyaya Sannihita with a maximum punishment of death penalty. For several minor offences, community service has been made an option of punishment instead of imprisonment. Provisions made of forensic evidence in the investigation, which will strengthen prosecution. One of the key highlights of the new bills is that they give doctors immunity against medical negligence. Currently, under colonial era criminal laws, medical negligence resulting in deaths is punishable under section 304A of the IPC. The revised criminal code laws exempt doctors from criminal prosecution. Video recording of the statement of the victim of a sexual violence case made compulsory, that is mandatory. There will be an independent director of prosecution in every district to decide whether appeals should be filed independent of the recommendations of the police or prosecution. Provisions introduced to fix the accountability of the police. Provisions introduced to ensure victim-centric justice. Provisions made for zero FIR registration. Victim can approach any police station, not necessarily the jurisdictional police station. The FIR will be transferred to the jurisdictional police station within 24 hours. Courts cannot allow the straw cases without hearing the victims. Serving of copies of the police report on the victim made compulsory. Victim to be informed of the progress of the investigation within 90 days. All inquiries and trials can be conducted in electronic mode. Offences against human body, offences against women and children brought to the beginning of the Bharatiya Nyaya Sanhita. For example, murder is now placed at clause 102 of the Bharatiya Nyaya Sanhita instead of section 302 in the IPC. Separate provisions to deal with offences against women and children. In case of rape of a girl under 18 years, life imprisonment and death penalty can be given. In gang rape, 20 years or imprisonment for rest of life. Sensual sex with a wife aged above 15 years was not an offence as per IPC. This age limit now increased to 18 years. For hit and run, the punishment is up to 10 years imprisonment. But if after the accident, the offender takes the victim to the hospital or police, lesser punishment will be given. Provisions will be brought to exempt doctors from the offence of death by negligence. This is following a request by the Indian Medical Association. Snatching has been made a separate offence. For the offence of grievous hurt, a separate provision made to deal with cases where the victim becomes brain dead to prescribe more stringent punishment up to 10 years. Provisions relating to FIR charge sheet trial. CRPC did not prescribe any time limit for FIR, but BNSS, but that is Bharatiya Nagarik Suraksha Sannihita, prescribes compulsory time frames. FIR has to be registered within 3 days of making a complaint in cases of lesser offences. For offences with imprisonment between 3 and 7 years within 14 days, preliminary investigation has to be completed and FIR should be registered on that basis. Further investigation has to be completed within 90 days of filing the first charge sheet. Leave of the court needed to continue further investigation beyond this period. Magistrate has to decide on taking cognizance of the charge sheet within 14 days. Time limit introduced for sending the medical reports of the victims of sexual violence cases. Timeline prescribed for filing discharge applications, framing of charges, deciding discharge petitions. Trial in absentia. If accused does not appear before court within 90 days, trial can be carried out in absentia. For first time offenders, if under trial detention for 1/3 period of sentence, then can be released. In other cases, 1/2 period. Judgment has to be delivered within 45 days after conclusion of hearing. Only convict can file mercy petition against death penalty. NGOs or third parties cannot file mercy petition. Mercy petition has to be filed within 30 days after the decision of the Supreme Court on appeal. EFIR provisions introduced for electronic registration of FIR. This will particularly benefit women who might be hesitant to approach police station to report sexual violence. Video recording made compulsory during search procedures. Visiting of forensic science laboratory team made compulsory at crime sites. Forensic evidence will ensure conviction rates will increase. Summary trials. Earlier, summary trials were possible only for offences punishable up to 2 years. Now it has been increased to 3 years. If no decision is taken on sanction for prosecution of civil servants within 120 days, it will be presumed that sanction has been granted. Provisions made for seizure of property of fugitive offenders. Earlier, in only 19 offences, the accused could be declared as fugitive. Now it has been increased to 120 offences. New witness protection scheme brought, which every state has to notify. Provisions introduced to sell material objects and vehicles seized in crimes with the permission of court within 30 days after taking video photographic evidence. This will lessen the burden of police stations across the country where crime properties are left undisposed for decades. Smartphone, laptop, messages, website, and locational evidence included in the definition of proof. Provisions introduced to allow use of electronic evidence as primary evidence. The hierarchy of criminal courts made uniform across the country. Classification of metropolitan areas and metropolitan magistrates removed. Thank you all. Please subscribe the channel, like and share this video. If you have any doubts, please comment.